Good evening to the students of the Advanced International Dispute Settlement Law. Karibu sana, welcome to the class. And we are dealing about the disputes where in the last class, we are in this place. I will show you the place where we are. Yes, here I put the conciliation, the asterisk mark, and I believe that you could see it. Dorcas, could you see the asterisk mark here? Dorcas, unmute and speak. You're
Yes,
speaking,
Prof.
but unmute. Yes, speak.
Yes, Prof.
Could you see the asterisk mark here?
No, there's nothing displayed.
Nothing is displayed.
Yes.
Here on the screen it is there. See, which I highlighted here. See, this is the thing.
Prof, I don't see anything.
See, no, it could be seen to you. See, here is the asterisk mark. Okay, if you did not see, at least could you see this one?
Now I can see, Prof.
It's only the thing, no. It is color, that's why you could see. And this is the two-day international conference, virtual means online, on mediation as a mode of settlement of disputes in the new millennium, a way forward. So this is also dispute settlement. Why don't you develop a paper? So somebody told me, sir, the paper goes with the cost. Don't worry, I will ask them to waive the cost, because here it is said that participants from the foreign countries is academician, legal practitioners, judicial officers, industry USD 20, student and research scholars USD 10. But I told them either you can waive this 10, and if you insist it, the student should pay, but I pay according to INR 500 on behalf of my students. I told them. And if you develop a paper, then I add my own content, and then we can make a joint publication. So I'm ready. If 3 members are making the publication, paper, I am ready to pay on behalf of you 500, 500, 500. So now you can think it over. Then you can tell me whether you present or may not present. Definitely I'm going to present the paper in this international conference. So here it is given the theme. I already posted you. I think you have read it. Sir, we did not read it, sir. Say, Dorcas, did you read it? I posted to the group. Answer. I posted in the group. Did
No,
you read
Prof.
it? What is the purpose of my posting in the group if you don't read it? Sir, no bubble data, sir. Sir, I am busy, sir. You have to read it what I posted on the screen. In the WhatsApp group. Okay, you think it out, read it out, then inform me so that we can go forward. Because these are the themes. On any theme that you can develop it. Each one take one theme and you develop it. These are all the bullets is given. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13. Around about 13 bullets are there. So you can make it out. It is a virtual. You need not to go. On the online, you can present the paper also. At least you could know that how to present the paper in online. It's only 5 to 10 minutes. You can easily make it out, and you can use the PPT. It's very easy. Make the PPT only 7 slides enough. First is introduction, last is Asante Sana. Thank you very much. Meanwhile, 5 are the original one. Each 1 minute you can speak. Then within 7 to 8 minutes, it will be over. So that you can make it the paper. So now, without wasting the time, let me go to our here. Now, could you see it now? Did you see now asterisk mark? No, Prof.
Yes, Prof.
Yeah. See, this is asterisk mark. Up to that extent, I dealt in my last class. Then we will see what is conciliation. So, conciliation, the process where the commission or a committee is appointed and the dispute is referred to them, and it is required by them to find out what the facts and then to write a report for the settlement of the dispute is called the conciliation. Did we cover this one or we did not cover this one? Yes?
We covered.
We covered. So naturally this we covered, but I did not put the asterisk mark for the other thing. And the specific settlement, Pact of Bogota. See here, I think it is session 2. Yes, session 2 means this one only. No, this is dispute settlement. Then I would like to see up to what extent we covered. Yes, settlement of disputes. General Assembly, we did it. And Manila Declaration. No, this has come. Yeah, let me see it, how far that we made it. Then Manila Declaration. Did we cover up to that Manila Declaration? Okay, let me check it. Let me check it, then I will come to you. Yeah, now let us see whether we have written up to that extent or not. Because we wrote there is a Manila Convention is there. The find. Because asterisk mark I put it over there, but it is not the asterisk which we want to take it. Manila. Yes, Manila Declaration. So, in our last class, I think we are here nearly. General Assembly. Of course, General Assembly, we have seen it, but let me again recap it. Okay, Dorcas, you read what is General Assembly. Read this paragraph. Dorcas, read that paragraph which I highlighted. This
General Assembly.
Yes, go ahead.
Despite the fact that the Assembly has not been empowered to settle the disputes using any specific means, it holds a wide range of powers to discuss the same under Article 11, Para 2, and may make recommendations under Article 14 to the parties in dispute, which may help them to arrive at peaceful and friendly conclusions. Thus, in simpler words, it can be said that the Assembly holds the general power for the peaceful settlement of international disputes.
Yes, sir. And General Assembly is one of the organ of the UNO. Am I right?
Yes, Prof.
I appreciate. We discussed the 5 organs and we already told that these 5 organs there in New York, only one organ is in another country. What is that? Only one organ is in another country?
International Court of Justice.
Where it is? Mbeya. Where it is?
In Netherlands.
Netherlands, the place is called The Hague. Okay, now let us see. Despite the fact
Yes,
that the
Prof.
Assembly has not been empowered to settle the dispute. If strictly speaking, General Assembly does not have any power to settle the dispute using any specific means. But it holds a wide range of powers to discuss the same under Article 11, Para 2 and may make a recommendation under Article 14. But when you see the powers of concern, yes, it can have, by virtue of the Article 11 and Para 2, it can have the power to discuss the same under Article 11 and Para 2 and may make a recommendation under Article 14. But if when you see the powers of concern, yes, it can have, by virtue of the Article 11 and Para 2, it can have the power to discuss the same under Article 11 and Para 2 and may make a recommendation under Article 14. But if when you see the powers of concern, yes, it can have, by virtue of the Article 11 and Para 2, and the recommendation to make the recommendation under Article 14 of the parties to dispute, which may help them to arrive a peaceful and friendly conclusion. But still, indirectly, the article give the power to the General Assembly, make them to move further to make the peaceful and friendly conclusion by virtue of the two articles, that is Article 11, Para 2 and Article 14. Thus, in simpler words, it can be said that the Assembly holds the general power for the peaceful settlement of international dispute. But in other words, we can say, indirectly, it is having a power to settle the disputes. Otherwise, it will not be made it clear under Article 11 and Article 14. Now, next we can see the further what this is the recap. We can make it out. There have been various instances where the Assembly has suggested for the peaceful settlement of the dispute. So there are many occasions are there and where this Assembly made a suggestion for the peaceful settlement of the dispute. In 1974, the Assembly called upon the member states to make full use and seek improved implementation provided in the Charter of the United Nations for exclusively peaceful settlement of any dispute or any situation. So, General Assembly made a suggestion in the 1972 to the member states. Yes, by virtue of the 11 and 14 also, you can try to use this charter for the peaceful settlement of these disputes. So that is the thing. Then the Manila Declaration. Then when you see the Manila Declaration in 1982, the committee successfully drafted a declaration that was to be adopted by the Assembly. Which Assembly? General Assembly. The same declaration was known as the Manila Declaration. The declaration mentioned in that the state shall seek any peaceful way of settlement of dispute in good faith and a spirit of cooperation. So the declaration mentioned any state by peaceful means of settlement of the dispute could make in a good faith and spirit of the cooperation. It also mentioned that the state had absolute liberty to make full use of United Nations. It also made it clear in the Manila Declaration that any state could have the full liberty to make the full use of the United Nations. So that is the Manila Declaration for the peaceful settlement of the disputes. The member states of the UN. The Declaration on Prevention and Removal of Disputes. A declaration was drafted by the special committee which was set to threaten the international peace and security. This declaration is to have been approved by the Assembly in the same year. Some of the important provisions of the declaration as follows. Which declarations? This is the declaration on the prevention and removal of the dispute is concerned. So some of the provisions are given here there. Number 1, foreign ministers level meetings to be held sometimes by the Security Council. So foreign minister level meetings should be conducted sometimes in the Security Council. That provision says. Number 2, the appointment of the Secretary General as a rapporteur in a specific dispute must be considered by the Council. And here the appointment of the Secretary General as a rapporteur to make the records of the session or the beginning of the disputes, specific dispute must be considered by the Council. Whatever the dispute should be there from the beginning to end, the rapporteur should have to make the record. So appointment as a Secretary General, as a rapporteur would be there. Number 3, fact finding or good offices should happen at an early stage. There should be a fact finding should be there. And what are the facts regarding the dispute between the two states are concerned, or good offices. I told you that what is a good office means a third country will use his office where these two disputed parties will resolve the issue by staying over there. Like we read it in the Shimla Conventions, in the Shimla Tashkent Conventions, and like Manila Convention, Manila Declaration. Of course, this is a place where it is made, but the Secretary for the Security Council is concerned, or the General Assembly is concerned, but generally the place where the good office will be given, and from that place the dispute will be resolved. Later we will see that in order to prevent a dispute, the Secretary General must consider approaching the state concerned. The Secretary General, who will be in a rapporteur also, you have to approach to the state concerned, those who are in disputes. So these are certain provisions should be given there. So this declaration is said to be the first instrument that deals with the prevention of international disputes and promote the international peace, harmony and security. So all these declarations are instrument to bring what? Promote the international peace, resolve the international dispute, make the harmony and live in security. So what are the fact-finding activities? In 1990, the special committee was asked to...
Prof, I have a question.
Yes.
Prof, I have a question.
Yes, please ask.
Do states which are in disputes allowed to appoint a good office?
No. Only third country could appoint the good office to resolve the issue.
Okay, thank you.
And the third country will give their own office. And where the parties will come and sit and resolve the issue. And the office which is given, good office, sometimes they will given the name of, suppose the office is there in a particular place. So they will give the name of that office as a so-and-so place declaration. Because they use the office.
Okay, what if?
Yes.
What if one of the state is not, maybe doesn't allow about the choice of the good office?
See, the point is, no, when the two member will come to an agreement and request the third country, please, can you act as a mediator to us? Then the third country, either the president or any remarkable person, not ordinary man. So we will come forward, he'll say, okay, come on, we will try to resolve our issue, come to my office. So these two people will agree to go over there and choose that office, and hence the office will take care of it and see that the dispute will be resolved. The reason is the country which brings it now naturally is a powerful country. Powerful in the sense economically or GDP or very advanced countries. So that would be there. And the parties, those involved generally, they are underdeveloped countries. Are you following me?
Yes, Prof.
So in that way, that the dispute will be resolved by using the good office. So now let me go further, fact-finding activities. In 1990, the special committee was asked to give the priority to the impending questions on maintaining the internal peace and security. For this purpose, the fact-finding activities were to be primarily considered. In 1991, a declaration on the fact-finding committee was adopted by the General Assembly. It had a major role in strengthening the role of the United Nations in the maintenance of the internal peace and security, and also to promote the settlement of the dispute through the peaceful means. This fact-finding committee is appointed by the General Assembly, and this will allow the country should have to allow the fact-finding members to investigate there. If they hindered over there, naturally Security Council will take the initiative, because fact-finding comes at that instance only when the two parties will agree, okay, if you think that we have committed that so-and-so thing, please come and check whether we did such an activity or not. So then only the fact-finding committee will come and check with the people, and they will interview the people, they will see the physically also, they will search it and to know the truth. So a declaration in the fact-finding committee was adopted by the General Assembly. It had a major role in strengthening the role of the United Nations in the maintenance of the international peace and security, and also to promote the settlement of the dispute through the peaceful means. So they want to settle the dispute with through peaceful means. The fact-finding committee will go and give the report to the General Assembly. The fact-finding mission was either taken by the Security Council or Assembly, both the way. Either Security Council will make it out or the General Assembly can make it out. The General Secretary or Secretary General was expected to use the fact-finding activities at an early stage for the easier and more peaceful contribution in matter of the dispute. So either the General Assembly or the Council will make it out the fact-finding, and the General Secretary will take the lead, or the Secretary General will take the lead, and he will be the rapporteur for the dispute, and he try to resolve the issue amicably by peaceful means. So that is the peaceful contribution in the matter of dispute is concerned. The fact-finding committee will do it, and they are appointed by either the General Assembly or the Secretary Council, and they will report the matter to the Secretary General. So he was required to, prepare a list of the experts in various fields who could carry out the fact-finding activities. Who has to require General Secretary or Secretary General will be required to make the list of the experts in various fields and who could carry out the fact-finding activities. Is it clear?
Prof, I haven't get a point. What is really happening in fact-finding? What are they doing?
In the fact-finding, what they know, they will go to the particular area, they will see the area, they take the opinion of the people. If any allegations are there, or really things are going on, whether it is a land dispute, whether it is any other dispute is concerned between the two states, the dispute come over there, so they will make it out as an original study and give the report to the Secretary General or General Secretary. And this fact-finding committee is either appointed with the General Assembly or by the Security Council. When, you may ask, when the two parties will agree together to make the allegations, to make it, okay, in the same manner, they go to the other country also if it is necessary to find out what exactly the thing would be there. So once they visited both the places and give the report, at that instance, because the Security Council will not come and check it, they will send the only fact-finding committee. For instance, you take in your court also, you know, commissioner, when commissioner will be appointed? Can you tell me? If any dispute would be there for the land, and he says that land is encroached in my land, he says, no, you encroached in my land. So the wall is constructed over there. A court will not go to there to check where actually the wall is there. So what the court will do, on the payment of the money, a commissioner would be appointed by the court. And this commissioner will do like a judge and go over there and check the people and measure the things and take the photographs and everything, then submit the report to the judge. In the same way, fact-finding committee also make such an inquiry physically and meet the people and go to the area and get the report and submit to the General Assembly, General Secretary. You know, commissioners appointed. Do you know or do you don't know?
We know, Prof.
Yes, the same thing. There the magistrate or the court will not go to the dispute place. Who will go? Commissioner will go. And who will appoint the commissioner? Court will appoint the commissioner. And who pay the money? The party who contesting that. Okay, I will pay the money. This is the clear position of my standing. And this commissioner will give the report to the judge. In the same manner, fact-finding committee will give the report to the General Secretary. Is it clear?
It is very clear, Prof. Thank you.
Very good, very good. I appreciate it. Please ask the questions if you could not understand anything. Okay? Okay.
Okay, Prof.
Handbook on the peaceful settlement of dispute. What is this? What is this handbook? Again, with the help of the special committee's recommendations to the Secretary General to prepare a handbook on peaceful settlement of the dispute and also to provide a special powers, functions and duties to the Assembly and Council and Secretary, an elaborate draft handbook is said to have been drafted by 1992. So this handbook will give what are the powers and functions of the duties of the Assembly, Council and Secretary. So again, with the help of the special committee, recommendations to the Secretary General to prepare a handbook on peaceful settlement of the dispute and also to provide the special powers, functions, duties and the Assembly and the Council and Secretary to elaborate the draft handbook and said to have been drafted within 1992. So this handbook will give the clear idea who are the powers, what are the powers and what is the fact-finding result also there, which is given over there in the handbook. The report will be prepared. So that is the thing we will read. Now let us come to the Security Council. And chapter 4 of the charter provides the various modes by which the Council settled the dispute peacefully. The major role of the United Nations Security Council, UNSC, within parentheses, is to maintain the international peace and security. This is the most crucial duty of the Security Council, to protect the international security and peace and confront whatsoever peace comes under the impedance. So it is the primary importance of the Security Council to see that if there is any confrontation, then that would be resolved by the amicable means and peaceful means, and internal security could be maintained. It has been mainly enacted to promote the peace revolutions, respond to unlawful manipulation of the force, solve the international conflicts, and impose approval in circumstances wherein the peace and security are coming under the threat. So what that they mainly enacted to promote the peaceful revolutions, respond to unlawful manipulation force. If anybody country is manipulating over there, respond to the unlawful manipulation force, solve the international conflicts, and impose the approvals in the circumstances wherein the peace and security are coming under threat. When peace and security under threat, they will impose some approvals, sanctions, impose them and try to curb them. Its spirits are prominent for undertaking the fighting circumstances and clarify the enormous reciprocal activity to react to the conflict. If any conflict will be there, permanent in nature, and they will try to fight against it and see that a peaceful means will be resolved. So its purpose is to examine the United Nations peacekeeping experiments, recommend upon the matters of the particular nations, and scrutinize the enactment of the consent by its authority. The Security Council may adopt the activities to safeguard the civilian from the dispute through enabling humanitarian organization or with or without any prior confirmation by the legislation of the nations. Generally, when the conflict would be there, the Red Cross Society will go, and many other organizations, NGOs will go over there to resolve the issue. Number one. Number two, if there are any victims would be there, the victims, if they are got injured, and they will be taken to the hospital and treatment would be given to them. So like these operations can be done with the help of the military activity, because where the disturbance is more, and these NGOs will not be allowed over there because they will be also killed. The Security Council may adapt the activities to safeguard the civilians from the dispute through enabling the humanitarian organizations like the Red Cross with or without any prior confirmation by the legislation of the nation, because they cannot wait till that things will come from the nations. They will go immediately. For instance, if any person is murdered or not murdered and met with an accident on the road, a doctor cannot say that please go to the police station and report there, then you come for the treatment. No. The jurisprudence changed. Criminal jurisprudence says, first and foremost, you make the treatment of the student to the victim. Later on, okay, you can request him to, or you can call the police station to register the case. So that is the mode. If the victim goes to the police station, meanwhile, this fellow will die. Am I right?
You are right, Prof.
See, instead of waiting for the confirmation of the legislation, they can send the team to resolve the issue over there. So moreover, it has the power to regulate the state to confine the stockpiling of the particular missiles or weapons by nuclear demolition, non-expansion of the chemical weapons. See, most of the countries, there is a treaty, non-proliferation treaty, regarding the manufacturing of the neutron bomb. So they will see that if you are preparing the neutron bomb for the peaceful means or to killing the other countries, the neutron bomb is very disastrous, and now the people are using the nuclear energy to make the electricity, to make the generation of fruitful means, because it produces a lot of energy. With that energy, they will make the heat. With the heat, they will make the steam. With the steam, they will run the turbine. The turbine will produce the electricity. Songo, what type of the electricity will be manufactured over there? Is it the thermal? Is it a solar? Is it a wind? Is it a hydro? Participants, did you hear my question? Did you understand my question?
No, please repeat, Prof.
Songo songo, songa songa.
Songo song.
While you are going from towards Dodoma to Iringa, you will come across in the middle. What type of the electricity will be generated there?
Songo Songo.
What type of the electricity will be generated there? Because I use the 4 terminologies here. Number 1, thermal electricity. Number 2, solar energy electricity. Number 3, hydroelectricity. Number 4, wind mill generating electricity.
Hydro.
It is hydro. The water falls from the Paramboko. Paramboko falls. It will falls on the turbine. Turbine will move it. When turbine moves it, then automatically the armature will generate. The armature moves. Armature moves. The electricity will be generated. Thermal, they will make the water heat. For the heat, they will make the steam. The steam push the turbine. The turbine push the armature. Armature will produce the electricity. So that is the mechanism. So this is now the nuclear weapons they are preparing or not, or demolition purposes, or chemical weapons are there, or the missiles are there. If any country has made such a thing, then the fact-finding committee will send over there to verify and check it and give the report. Even though it can decide on the presence of the danger to the peace and activity of invasion, suggest what procedure ought to be adapted. So when such a country makes an allegation that, then the 2 countries approach to the UN Security Council or Assembly to see that the dispute will be resolved. If there is a requirement to enact the diplomatic ties, severances, economic restraints and fines, united military activities, then the Security Council can take an action on the matter. Suppose if the other nation will not listen, will not allow the fact-finding committee to enter, at that instance, a sanctions will be imposed by the United Security Council. What type of the sanctions? Diplomatic relations will be severed. Means embassies will be removed from that country, and they don't allow any person to be either passed to that country or coming out from that country to another country. So diplomatic relations will severance is there. Then economic restraints. Suppose if the export and import would be there to the country, they will stop the export. Economic restraint, and they will impose also fines and united military activities. Even they will send the military UN peacekeeping force to curb the such situation and control it, so that there would be security and peace would be there. Activities, then the Security Council can take an action on the matters. See, when the war between the Eritrea and Ethiopia was there at 1999, if I not be mistaken, then the United Nations peacekeeping force entered over there and they resolved the issue. So besides, UNSC, United Nations Security Council, has the authority to create the agendas for the organizing the policy to operate the armaments and to suggest the procedures of negotiations such as conflicts or the phases of settlement in the peaceful manner, as well as implement the financial penalties and supplementaries. So when the UN Security Council enter into the dispute, resolving the dispute, they will take all the measures should be there. If that country will not listen, then the economic sanctions and diplomatic relations will be tight, and export-import will be stopped, and even to curb such activity, UN peacekeeping force will be sent over there to see that peaceful means the matter will be settled. So that is the thing which are not regarding the practice of force to prohibit or quit the violence. So here, implement the financial penalties. They will also impose financial penalties and supplementary regulations, and which are not regarding the practice of force to prohibit or quit the violence. And they want to see that the violence will be removed and the practice of peace will be maintained. So that was the thing which we studied there. Then comes the Secretary General. What is the role of Secretary General? Here the United Nations Secretary General, UNSC, and an individual who is deemed to be symbolic of the benignant that the archetype of the equivalence and carry on involvement in achieving the peace among states. At this time, the Secretary General visits the United Nations Conference and talks with the global administrator for the remaining the significant national and international ties. And he will act as a mediator and see that the dispute will be resolved. In times, any dispute, the United Nations Secretary General ought to bring its opinion in front of the United Nations Security Council. So, if any threat would be there, he will bring to the notice of the Security Council, who Secretary General, and take the assistance for the activity. This function imposes the supreme obligation to protect the international peace and security if any disputes are arising between or within the boundaries. Either between or within the boundaries would be there, the UN Security Council, with the power of the General Secretary, will handle such a situation and see that normalcy would be brought. This function imposes the supreme obligation to protect the international peace and security if any dispute are arising between or within the boundaries that goes against the international security or the principle of human rights. Then UNSG would be cognizant and prepared to reconcile the contribution. So here the United Nations Secretary General and the United Nations Security Council will take the cognizant of the things and try to resolve the issues. If the other country will not listen it, then the diplomatic relation will be tied, economic sanction will be moved, and the penalty will be imposed. If necessary, UN peacekeeping force will be sent over there. So on the other hand, Article 99 of the United Nations Charter gives that the UNSG, that is the United Nations Secretary General, would take to the scrutiny of the Security Council any issue which is, in his opinion, may threaten the maintenance of the international peace and security. So they will be brought to the notice of the then Security Council may see the issues and his opinions and try to resolve and maintain the international peace and security. Therefore, the provision of the Article 99 would determine significant and may be enforced properly. So Article 99 gives the power of the United Nations Secretary General to act and scrutinize if there is any dispute among or within the boundaries are there or not. So that is the role played by it. So now let us go to the judicial settlement is concerned. When a matter comes to judicial settlement, is the process of resolving a dispute by the international tribunal. So it is a judicial settlement. It is through the tribunal the matter will be resolved in accordance with the rules set by the international law. And here it is important to understand the expression international tribunal. What is international tribunal? Is it like a court? Yes, it is like a court. But in a specific occasion, tribunal will deal it. A tribunal acquires an international status because of its jurisdiction. At the present day, the International Court of Justice, although not only the tribunal, but is indeed the most important tribunal around the globe. Yes, International Court of Justice, it is a
So I spend a lot of time working on social media for my clients. I create a lot of video content